Hello and good afternoon, good morning, and good evening, everyone. Welcome to the nasscom webinar on Personal Data Protection Act. This time we are going to be focusing exclusively on the corporate governance aspect of this law. And we actually have a packed panel. And let me start quickly by introducing the panel, which has actually joined from different parts of the world. We have Stephanie Higgins, who is the Chief Privacy and Data Ethics Officer from Cognizant, and she brings a wealth of experience over 2 decades. And what we are looking specifically from her is maybe to talk a little bit more about the contrast with in terms of implementation in the Indian context, as appears with respect to GDPR and other regimes that she has had experience of working with. And then we have Monika Tomczak-Gorlikowska, who's the Chief Privacy Officer at the Prosus Group. Again, I think interesting thing is that you invest in a lot of startups. So I think that context is going to be relevant. She's a member of the advisory board of the International Association of Privacy Professionals. So I think some of the conversation that you are part of in this context would be relevant. And then we have Bibhav Pradhan, who brings hopefully brings in again a very different perspective. He is the senior legal counsel at Unilever. And I think Unilever, because the fact that you will have a lot of digital businesses, but also a lot of non-digital trail, I think that makes it an interesting conversation for us. You are part of the leadership team and also the data privacy advisor at South Asia at Unilever, and think that will be something interesting to hear. And then finally, in terms of if you look at industry, we also have Abhijit Gangadhar Poonja, who is Director Legal at Flipkart. And the interesting thing about Abhijit is that he has worked in the industry across various segments. He has been with Infosys, Cisco. He actually started with the law firm, so I think we're going to count on that experience also, and really look at it from the tech industry perspective. And then, of course, EY has been our knowledge partner in this. You work with various clients. You are looking at the cybersecurity practice, and I think some of what you're hearing from your clients is going to be very useful. So, and of course, Varun, who works with me on data protection, and he has been tracking and being part of the policy team to really lead up to where we are not discussing the bill, but the actual law in terms of implementation. So I think I'll just make a couple of points. One, this is a brand new law in India, and we don't yet have the board which is going to kind of handle the complaints or issues which arise out of this. Even from a government perspective, they're shifting gears to get into the implementation stage. So from a governance point of view, I think what is also important, in addition to just complying with the law, is that how can we effectively demonstrate that compliance to the government? Because if I were to say it, in the initial years, that will set the tone of the relationship between the government and the board and the industry. So if that experience is a positive experience, and the data protection board and the government sees that, and they also develop their capacities in over the next few years, I think we can have a good transition into this law. And we are actually having conversation with the government and feeding it into some of the conversation also around the capacity which the government needs to put up, and that's going to be important. And the second point is, I think we are trying to now shift away the conversation from a very legal conversation to say that, okay, what does this mean? And all of that, to say that at a company level, how does this translate into a strategy, into the business model and the operating models of the organization? And how does the board of the company starts looking at this from a responsibility and a governance framework? So from an industry point of view, those who are listening in, I think the panel will try to bring a little more real world experience into this, and that's what we are hoping to do. So with that, Mini, may I request you to give insights into the survey which you just ran, and then we can take this forward. Yeah.
Thanks, Ashish. Hello, everyone. Pleasure to be here. So what we wanted to do in the next 5 minutes is probably just showcase to you a glimpse of a survey that we ran, and this is across corporates as well as consumers that we were running, and these are more than 100 corporates that we looked at and multiple consumers that were involved. Now, broadly, if you look at it, is my screen visible?
No, not yet, Mini. If you could just reshare.
Okay. Right. So while that comes up, broadly, if you look at it, there are good insights that have come up. We'll just talk about some of the key highlights that we wanted to showcase, both from a perspective of corporates as well as consumers. I think this is.
Yeah, the screen just is about to come and then it goes away. So, Varun, do you have the slide?
I'll just retry once and then we can probably go with Varun. Let me know if it's visible.
Nope, it's not here. Do you want to quickly talk about it?
Sure. So I think let's just quickly talk about what the survey really has to say. Now, when we looked at it from a corporate point of view, there were multiple aspects. The first one we asked the corporates was how concerned are they about and how much are they aware of this? How well do they understand the law that we have? And it would be, it was a majority of the organizations, 52%, said that they're very concerned about the potential impact of the upcoming privacy regulations on its operations and data handling practices, to be precise. And this indicates a significant recognition of the potential challenges and impact these regulations may have. Further, if you look at it, when we checked upon what are these challenges that they foresee, the most significant challenge that the organizations mentioned was the technical implementation. About 32% mentioned that the entire technical implementation, looking at changes in their systems, looking at how they will manage the whole data subject rights management in an automated fashion, in fact, consent management. So the automation around that is something that they voiced as significant and demonstrating that they anticipate difficulties in implementing the necessary technical controls. Now, in terms of resources, so while we've got the challenges, we've got the comfort factor. In terms of resources, again, when we looked at it, they said that the privacy skill set is definitely something that we need to focus on. And majority of them, in fact, more than 50% claim that they do not have the required skill set within their existing resources. And in fact, they're looking at ways of upskilling, they're looking at ways of partnering with organizations that have the skills, or even look at how they can mobilize the resources internally. But skilling definitely is an area that we need to look at. So broadly, if you look at, there are many other challenges in terms of lack of clarity in the guidelines. There are certain rules that we're still expecting. So that again is an area of concern that organizations have highlighted. And clearly, it indicates how while organizations are gearing up, there is a lot more that needs to be done and a lot that they need to further work on. Now, if we move on to the consumer perspective, so while this is from an organization perspective, if we move on to the consumer perspective, there were two key elements that we looked at. One is, how comfortable would the consumers be interacting with organizations that deal with personal data and, that personalize advertisements and offers. So if you look at it, majority, 61%, are not comfortable at all with companies using their personal data to personalize advertisements and offers. So this definitely showcases a high level of concern and skepticism regarding the privacy and data usage practices. And further, if you look at it, a good 68% of respondents are very likely to trust a company that communicates its data protection practices. So clearly the intent at the top is what they're looking at. They're looking at more transparency, effective communication, and it would also act as a differentiator for corporates in the eyes of a consumer while they demonstrate better data protection and overall governance practices. So this is broadly what we wanted to quickly highlight as part of our survey. Of course, we can circulate this further as well, but just a quick, thoughts on what the corporates and consumers are also talking about. So Ashish and Varun, over to you.
Thanks, Mini. In fact, it just underlines this point that you don't just have to implement compliance, you need to demonstrate it, and you also need to communicate it, because clearly that's going to be very important for the consumers. Great. So, Varun, I'm going to hand it over to you now. I think we have some interesting questions lined up based on our feedback from the industry. So let's start this conversation. Yeah.
So thanks, Ashish, thanks, Mini. And so I think as we look at the different requirements that a governing body of a company needs to look at, the starting point in the Act is the requirement for a data protection officer. It's required from significant data fiduciaries, but also from all other companies when they think about who is going to be responsible for grievance redressal in their organization, which is a market-wide requirement. And so data protection officers also need to be independent from other business functions. And at the same time, it's important that companies don't think of them as just cost centers or just check the box compliance requirements, right? Like, so we need to understand and think deeply about what the role of a data protection officer can be. So with that, actually, I wanted to come to you, Stephanie, to help us think through this issue. So what should companies be thinking about when they define the functions of a DPO, when they give it resources? And one interesting question from the industry is, can an existing function such as the CISO of a company or legal counsel of a company also fill this role? What are your thoughts on how companies should be setting up the DPO role?
Sure, very, very happy to provide my views. Hopefully everyone can hear me okay.
Yeah.
But let me know if there's any issues with the sound. It's a really good question. It's a really good topic. I think to a certain extent, a lot of companies as well as regulators are still grappling with the same questions in Europe 5 years after, is it 5 years? 5 years after GDPR. So it's really interesting, and it will be very interesting to see how it evolves in an India context. A few comments, and please do pick me up if I don't answer every bit of your question. I'll come back to that. But first of all, I think from a European perspective and in the industry I'm in, the question is, do you need a DPO? Hopefully requirements in India will be clear, but in Europe, legal requirements around the DPO are not always black and white. And so a lot of organizations voluntarily appoint a DPO in role. And there are different issues and considerations with that as well. So it can be a very good practice, something certainly clients and customers will expect. And that is something that organizations should think about when they define their privacy strategy and where they want to be as an organization. Privacy, obviously, and data protection is very important for all businesses these days, but really, really critical for many who are operating in a fields with lots of data. And so building that trust as opposed to simple compliance through the use of roles such as the data protection officer, I think is really important and a very something that organizations should give a lot of thought to. How best to resource that role? I think it's going to depend on the starting point, really, and the existing compliance structure that an organization has in place, and obviously also resources, what is available both in the market to hire someone in, but also who have you got internally with capacity to take on this significant role. For organizations that don't already have a mature program, so they may not have been operating in a jurisdiction with a comprehensive data protection law previously, I think it's worth being pragmatic. I think they should have a long-term plan, but look at how they can get their program built up, get these roles in place, but have a long-term approach to what they want to achieve in terms of maturing their organization going forward. And that is where the role may sit. And again, generally no right answer there, but where the role may sit, and really having the role that is adding value to the organization as a sort of trust agent, customer trust agent, as opposed to a compliance tick box role. If you have an existing privacy team and compliance program, you may already have a group DPO. You'll need to consider whether you need a country level 1, I believe under the India law, there is a requirement for the DPO to be in country. And so a lot of organizations have group DPOs or individual country DPOs or divisional ones, depending on how they're structured, and that needs to be considered as part of your planning. And again, having someone available for a local appointment. In Europe, I'm not sure if this is the case in India or whether we know, but in Europe, there is the possibility to outsource the DPO role to a third party, to service providers or vendors. There are companies that offer this service. And it can be worth looking at that approach. I think there are pros and cons, and it really depends on your starting point, the size of your business, the level of support that may be available in the particular market that you're in. And I think really it's important just to get some of the basics in place and formalize the process as much as possible. So, I'd strongly recommend you look at already a letter of appointment or a job description for the role. Start considering that. There are lots of templates and examples out there from other jurisdictions that can be used as a basis, and develop a policy or a procedure around the appointment. So again, outlining the role or the job description for the role and the requirements for appointment. So this can really make sure we're managing any independence issues. It can cover any potential conflicts as part of that appointment, which is, again, if the role in place it already exists. So if the role is being given to someone who works in security or has another leadership position within the organization, and that will help you understand whether there are any particular independence or conflict issues that need to be considered, and really goes just a long way to demonstrating the compliance process you've got in place. I think it's really important in terms of the value add to the organization to take the starting point that this is not a pure compliance role. It is more than that. It is supporting your business, helping your business do the right thing with data, enabling your business to use data in a way that meets your objectives. And so the role should be viewed as really a stakeholder for the business teams, for marketing, for all parts of the business that are using personal data that is in scope. I think that's really important. And if you are at a starting point, that's a really a good way to try and frame this as an organization rather than just pure compliance. Was there anything I missed?
No, Stephanie, thank you. That was actually, you covered everything that I asked, and I'd love to just be mindful of time and come to Monika actually next about, you obviously work with a lot of startups and you've seen data protection at various stages of maturity across many organizations. Can you help us understand now that we have a law and we have to think about accountability in the real world now, the principle of accountability? What does that actually mean and require from an organization? And could you give us a few examples of things that companies need to do to build in accountability into their businesses?
Thanks, Varun, and thanks very much for having me and sharing a few thoughts and experience that we have acquired working with multiple companies in India, as you said, with varying business models, varying stages of maturity of their corporate governance program overall. And people often ask me, where to start. And I always say, start with executive buying. And I think Stephanie mentioned this as well. I think corporate governance generally as a model in your organization is something that needs to be adjusted and cater for those new obligations, which I very much second the approach that this is not a purely compliance related exercise. And I think we had the scientific evidence by the numbers that Mini has just presented. Most organizations will be looking at it as to, how to really fit it into business model. And speaking about practical examples, you'll be having a very different job in front of you if you are like a small startup that is exploring assistive technologies for the disabled. That's a program that as a group we support because you will be small but exposed to the necessity to process a lot of, data that has sensitivity. And therefore, you will have to look at your corporate governance program with this pair of eyes and maybe focus on, the security of the data as your first priority, and the appointment of a privacy leader that has technical and organizational knowledge and skills. If you are a company that is a marketplace, again, you have a different approach because you probably want to look very much at your externally facing elements of your privacy program, at how you're going to address individual rights of your, thousands or if not, hundreds of thousands of users, how you're going to build this. And without executive buying, both those tasks are very difficult to achieve because they're not just compliance-based paper, work, but they require investment either on the side of, security enhancement or documenting the security program that you already have, or on the side of building the necessary efficient processes in order to be able to address, as I mentioned, individual rights or incident management, another very important operational side. So for companies of varying size, the priorities may be different, but one thing is for sure is that the executive buying will then lead you to looking at those components of the program and how they work together. Because even though the A word is not used in the DPDPA, there's no sort of explicit accountability reference. If you look at number of the operational obligations that are part of the law, you definitely have to look at it in its totality and see how you can link. Another practical tip is also to look at what is there already, which processes and allies across the organization you can work with to achieve some of your goals. I think in particular at the sort of, old times of getting ready for GDPR, some privacy offices had the tendency to build something on their own for their own purposes. And that very quickly proved to be, not efficient and sometimes, leading to a failure, rather than looking for existing processes and fitting the components of the privacy requirements into that. So I'm referring, for example, to existing customer service operations, referring to your CISO program in terms of data mapping and security and technical and organization measures, looking at your risk and control function if you have it. If not, maybe just looking at your audit requirements as a company. There's elements of risk management there as well. So I think that this is also a way to look across the landscape of the obligation and see, how you can prioritize and how you can identify the ones which are just non-existent. And in terms of the advantages, let's look a little bit on the positive side of things. I think, again, I very much like the survey results because they brought evidence to the fact that a lot of companies will look at it as something that they need to have in order to function in the business environment in different roles. And we can take the optics of an investor company like ours, which will be expecting some forms of privacy program maturity, depending on the business model. So, investors will be looking at it. In a B2B context, this will definitely be your competitive differentiator. And the ability to demonstrate or even exceed the requirements will be perceived as a sign of assurance and trust. If you are in a consumer business, again, there probably will be some forms of arms race in terms of how companies want to present themselves towards consumers that we've seen in other parts of the world, like Brazil, when they've adopted their own privacy law. But all of this doesn't come without challenges and without a lot of operational work. So we hope that companies will have enough time to go through this. Have I covered your questions, Verona, or is there like a follow-up that you'd like to ask?
No, that's great. And we'd love to come back to you.
Maybe, Varun, if I can interrupt. Monika, I just had one quick follow-up, if you can. Since you have been in conversation in India, both in the investor circles and also the startup, as a ecosystem, at this stage, from a founder perspective, are you seeing this as something which is there on the dashboard as a governance issue, or your sense is that is yet to develop? A quick answer would help.
Thanks, Ashish. Very good point. Actually, we were very much amazed by the awareness and realization of founders of startups, in particular in the tech sector, on the importance of privacy and security governance. And they definitely, reached out for any opportunity for upskilling, benchmarking of what they had implemented already, even in anticipation of the law. So I'm not saying that those startups will not have still work to be done, but at least some of the baseline components like transparency requirements or security of the data, or even looking at privacy enhancing technologies, I think this is already something that the startup community in India is aware of, and it's not, won't come as a total surprise. The question will be how to, reach that point of, sufficient adherence to the multiple requirements that stem from the law across the landscape.
That's interesting and quite encouraging, in fact. And maybe if I can take the liberty, Bibhav, to ask you, as we were discussing earlier, right, in terms of just the nature of the business in the industry you are in, it has a complex supply chain, it has a equally complex, or let's say, big distribution chain, and all of them are part of the ecosystem. So when you're thinking about personal data protection, and when you want to look at a from a governance point at an organization level, so how do you secure the governance at a board level? What kind of thing that are essential, if you can break it down to a few of the elements, so that the board can be satisfied that the governance is in place? Maybe if you can talk about this as you share your opening thoughts.
Thanks, Ashish. I'll try to address that. First of all, I think a lot of details and elaboration has been provided by Monika and Stephanie, so I'll build on it. I think one of the things that, before I start and provide the context for Unilever, being a CPG industry and the impact here, one of the things, at least in the last 3 years of delving into the law, advocacy, and operationalizing compliance, what I've realized is that each organization is dealing with its own complexity and problems or ambiguities of compliance. Just to give an example, while there's utmost scrutiny on tech organizations like Meta, organizations with heavy influence of the public, we have our own set of complexities because we are not so tech driven. While we have a huge digital operation, we have an offline side of our business also, as well as the expanse of a large organization creates operationalizing compliance a big problem. So one of the things I would want to build on, and how we started on this journey, is a couple of years back, and I think I'll have to give credit to the GDPR, being an Anglo-Dutch company headquartered in London. We had to work towards compliance when the GDPR gave its time in 2016 for compliance. So a lot of systems towards consumers were built or borrowed from the global practice. So that I can't deny, and that we have an advantage of, which not every organization will have. But nonetheless, there are ways to go about it. I think the most important aspect of building governance around is executive buy-in, as Monika stated. There is a level of investment required in terms of resourcing, bandwidth of the resourcing, whether you have to create a data privacy officer or office who will work towards operationalizing compliance as well as raising awareness, right? So therefore, executive buy-in was very important. When the 2018 Sri Krishna Committee report came in, we started that executive buy-in then. We used to present it to the senior management, whether it's the management committee headed by our CEO, or whether it was the board of directors. We've made multiple presentations in the last 2-3 years to them to apprise them of what is being expected, what's going around the world, a bit of context setting in terms of how this law will impact, whether it is a 1 billion or 800 million fine to Meta or a 5 million fine to Spotify. In that context is to be provided, so that there is not a panic, but some kind of urgency to provide that support from the top down. And that's how you should start, because if it is not top down in a large organization, particularly, when it trickles down, the operationalizing of compliance trickles down, it fades away. And therefore that messaging is very important. After that, I think what we did was evaluate, and that is one of the most important aspects for any large organization, is the data discovery process, or identifying where and what data you're processing and for what purpose and where it lies. That was one of the most humongous exercise, and we are still continuing it with it. And therefore, I firmly believe that a 6 to 10 month timeline that the government is looking at to transition and comply with the law would not be sufficient, because if you look at GDPR also, as Stephanie touched upon, even after 5 years down the line, they're still struggling with a lot of answers. Just to give you statistics, IAPP had done a survey after the GDPR 2-year transition period, after 2-year period, and when we asked organizations, only 35% organizations in Europe were confident that they are fully compliant with the GDPR. The rest, 65%, thought that they were lacking in some form or the other was a survey. So therefore, the transition time towards compliance, you need to invest towards data discovery. Then once you've understood the plethora of data processing.
Bibhav, may I just interrupt? So
yeah, sure.
Okay, we understand transition time, but what are you doing in that time? And I want to understand it more from a governance perspective. That what are these activities that take time from a governance perspective?
No, fair enough. So once you've done the data discovery exercise, then one of the big issues that we've identified as an organization is third-party risks, data processor risks that come about because we are accountable. And from a governance perspective, what we decided is, first, we've constituted a local data council or privacy board as such within the organization, which is responsible and answerable to the board on the preparedness of compliance, as well as any work or work streams that are being monitored or led by that team. Now, the DPO's office or the data governance office is reporting to this data privacy board, and that is one form of governance we've done. The other is that we've borrowed and relied on existing practices, as Monika mentioned. There is a third-party compliance that we generally do, and most organizations already would have cybersecurity practices, cyber assurance practices when you launch any activities or tools, etc. Right? So we've relied and leaned on these processes to establish governance. So what we've done, we have relooked at vendor onboarding, third-party risk assessment that were done, which were not privacy focused, and converted them into privacy focused third-party risk management. When you onboard a vendor, having the right questions in terms of what data they're processing, the kind of contractual obligations that you should impose them with in your contracts, etc., that comes out of a schedule, out of that assessment, is something that we have relied on with existing processes, but tweak them to build in privacy by design within those processes. So third-party risk assessment, there is something called information security assessment that most organizations have as part of the cyber assurances. We've relied on that to build another set of governance, because that ensures the data protection in compliance aspect of it. Once that process or any activity has undergone that process, there'd be a certain sense of secure comfort in terms of informational security. So that is one. Those are the three bits that we've relied on. I'm not spending too much time on the granularity, but having third-party risk assessment process built in, a board, because you're not able to present it to the senior management at every occasion, having a dedicated office, because one of the learnings that we've had is that having certain internal understanding, internal monitoring is necessary. While GDPR allows outsourcing of a DPO role, India, at least for the SDF, would not allow, is what I understand, it being based in India, and this governance. And then I can tell you about future programs that we are trying to launch, but would wait for the regulation. So one of the things that we're looking at is recurring meetings with the audit committee. Being a public listed company, we are heavily monitored, as well as have an audit committee scrutinizing a lot of our practices. We are planning to establish a recurring internal audit program, which reports to the audit committee, independent of the data privacy office of the data privacy board, and update them on gaps, non-compliance, etc. I think these were the couple of things that we have done beyond the rest of the things that Monika talked about, training, incident management, etc. These are the governance structures, at least, we've built within Unilever locally to ensure compliance and monitor preparedness.
All right. No, thanks. Very useful, Bibhav. And in fact, the thing which I also caught is that the person who's in the hot seat as a DPO or in that kind of a role, I think it is for him to raise the flag and make the board act quickly, because that top-down approach otherwise could get delayed, right? So that again is, I think, important.
So Ashish, just on that, on the DPO bit, I think, and that's what, as Stephanie mentioned, it's a conversation that has no right answer. Anybody can become a DPO. Even there was a question that whether a legal professional can, they can. I think it's the organization's context that you need to understand properly as to where can compliance be driven better. Is your legal team strong enough, which has a voice within the board, because of which you would want to give the responsibility to legal, because they heard better in terms of governance risk? Or is your organization so complex that a technical person will not understand the data or technology infrastructure to really give practical compliance implementation? I think that is very necessary. Whether you go to any expert, a mini or any law firm, I don't think so they'll be able to advise you without the context of the organization. And you will see both legal as well as.
Yeah, I think that is important, because I mean, depends on the nature of business and the kind of relationship the board and internal structures have within themselves. So Abhijit, coming to you, I mean, Bibhav already pointed out to some of the complexities, and we do understand that Bibhav has the benefit of GDPR experience at some level. Now, if you just look at it from a whole lot of industry, which could be digital, but haven't had the need to really implement GDPR or any other foreign regime, and this being the first instance of looking at now saying that, okay, the law is here, and we move from this SPDI rules to a full-fledged law. So again, from a governance perspective, I mean, the presumption I would have is that the basic governance would be in place, right? So that's not something that you need to create. But what is it from a personal data protection point of view, from a risk mitigation and governance point of view? I mean, where do you start? And what are the, even if you can't do everything, what are the 3-4 things you must get it right and fairly quickly? I mean, what would be your thoughts on that, Abhijit? Yeah.
Thanks, Ashish and Varun, and it was really nice listening to the rest of the panel and give their perspectives, right? But it sometimes feels when we have these conversations that we just forget 43A existed. It sometimes feels like people don't realize that there was traces of privacy law in the IT Act, and that we did build some cultures in the last, 15 years, right? Since 2008, the amendment. If you look at the elements of 43A, and there's a reason I'm starting with all this, and I'll get to what you're asking, Ashish, is it already built the fact that we need to protect personal data. That's a cultural shift. So when, for example, the POSH Act came about, the Prevention of Sexual Harassment Act, there was already a judicial precedent in the past which had given guidelines on it. So there was already traces of that before a codified law came. Similarly, with the privacy law, 43A already kind of built that premise that there is a need to protect personal data. Then you had the Puttaswamy judgment, right, which said that privacy is a fundamental right. So the everyday citizen realized that their data is important because it got coverage right at Supreme Court. You see other pressing issues now in society which are also being debated at the Supreme Court. So with the Puttaswamy judgment, that put a further emphasis on the fact that privacy is important. So when this law started coming about, interestingly, Ashish, and all of us know this law didn't just get enacted overnight. How many bills came since 2019? So it has slowly been putting that thought in organizations and people that privacy is important. Privacy is intrinsic to our fundamental rights. And you need to have a culture of compliance to be able to protect the organization and, more importantly, protect the data principles. So why I said that is, what are those cultural shifts, organizational shifts, compliance shifts we need to do? I'm saying all of that has already started in shape and form. This law is now just giving us direction. That's why I opened with that. Now let me talk about the law itself. If you see, the law is called the Digital Personal Data Protection Act. That should tell you automatically that tech is going to be the answer to how you get compliant with this law and how do you build robust processes, robust systems. Because it very clearly talks about in the applicability section that it applies to personal data that is stored in the digital form or collected in the non-digital form and then digitized subsequently. So it very heavily relies on the fact that even the lawmakers realize that we're really talking about how data is stored, how data is collected, how data is used, retained, etc., etc. And all of that happens through your systems and tech. And if you look at various provisions of law, you look at the fact that, look at the language options. It's telling you, even in the intermediary rules that came about last year, that you need to give multiple language options to folks to be able to even understand what are they signing up for. The 8th schedule languages and English. How do you enable that kind of sophistication for catering to multiple demographics? It's tech. You need to have the tech capability to give those language options. Let's look at consent. It very clearly says that you need to get affirmative action. Affirmative action meaning that the data principal has very clearly confirmed that they understand why their data is being collected, for what purpose, and how it will be used. And they have accepted it in a way that you can evidence that they voluntarily signed up to it. They opted in. Now, how do you show that? If it is the Digital Personal Data Protection Act, you show it through tech. For example, when you click I accept, when you click continue, when you go back and say I consent. How do you evidence all these things? It flows from tech. So even another provision of law I can talk about is data principal rights. The right to access, the right to erase, the right to modify, the right to nominate, the right to do a bunch of things that you see even in the GDPR law. How do you track these rights? How do you extend these rights? How do you implement these rights? It's tech. So if you ask me those 3-4 shifts, I think first it has to be a mental shift, which 43A, Puttaswamy, a bunch of things got people already thinking in that direction. So we have kind of won half the battle with the mental shift. The adoption of tech, whether you're a startup, whether you're a very sophisticated company, whether you had GDPR access, whether you don't, tech is the key. And with most applications nowadays, most interfaces nowadays, it's moving even to the cloud, which means you need to have even more robust tech systems, because it's not cost effective to have tech sitting in your own environment, right? It's cheaper to do it over the cloud. That's the whole premise of SaaS-based solutions. How do you keep the sanctity of that data? How do you keep the integrity of the data while also being commercially agile? So the second thing I would talk about is investment in tech. Your R&D org, your tech org, your CTO organization, working very closely with your legal team and working very close with your compliance team, if those are two different teams, is absolutely essential. Because the way they design the systems, the way they do data mapping, classification, segregation, usage, retention, that's going to be the basis on which you're going to be able to evidence your compliance with the law. So the CTO org being a key stakeholder or a key partner to the legal counsels and to the compliance function is key. And the final shift I will talk about is, you talked about corporate governance. What is corporate governance? Are you running the ship with the right intent and in the right spirit, being transparent, ethical, honest, and integral, right? That's what it's all about. How do you evidence all these principles of compliance? How do you evidence these principles of corporate governance, which is also enshrined under the Companies Act? By having all these cultural mental shifts, having the tech shifts and tech investments, and that's how you are able to go. If it's once a quarter board meetings, audit committee meetings, you're able to go in front of them with dashboards, analytics, reports, talking about your compliance programs. So I know that relying
Abhijit, if I can just quickly come in, sorry, is that when you, and we agree with you, but I think when you go in this journey, do you see the kind of tech solutions that we are referring to? Are they available? Are they deployable at scale? Or are there certain areas where with the best of intent and knowledge, you're moving in the direction, but you kind of come back and say that, okay, I can't figure it out. So I think some feedback on that would also be useful from an overall ecosystem perspective.
Ashish, I'll just take one step back in the tech journey, and I'll answer your question directly. When very complex logistics companies were there, which had huge warehousing and transport and whatnot, when you had companies doing payroll and you had a lot of, say, finance ledger entries that had to be managed, did they have solutions for that? Forget all the Privacy Act and everything. The answer is no. You then started seeing very turnkey solutions coming, either to specific to that industry or in general. And that's how your CRM tools, that's how your ERP tools started coming, SAP, Oracle, and the various companies started coming out with it. If I have to give you a straight answer to your question, I don't think those tools exist today. There are shades of tools being able to do certain things, but there isn't a tool sophisticated enough to do what the current law requires. But having said that, isn't this a journey, Ashish? And I'll give a very blunt assessment. Do we have a choice? Do we have a choice to not have our tech scale up to what the law requires us to do? That's how these ERP, CRM solutions all developed. So if you ask me, I think this is going to be a booming industry for those in the tech space to create these solutions for various clients. Obviously, these will be very regulated solutions, like your financial services companies have tools that they use internally because you'll have reporting obligations and whatnot. I don't think we're there yet, but I do believe that there are enough enterprising companies, entrepreneurs in this country or outside who are going to start building those solutions. I do believe that.
Thanks, Abhijit. In fact, as nasscom, I think we are talking to all kind of stakeholders, and we have a very thriving startup ecosystem. And generally, I think just listening to Bibhav and you, I think there is a huge opportunity which the startups and a lot of companies in the privacy enhancing space are looking at. So that's interesting. Varun, you have some thoughts?
Yeah, thanks, Ashish, and thanks, Abhijit. I think point well taken about the fact that a surrounding ecosystem is now going to have to come up. So as companies now look at meeting different requirements, that ecosystem that allows them to, meet these requirements efficiently is something that we hopefully will see grow in India. But the Act, apart from just looking at tech solutions that can help you meet certain requirements, the Act also talks about certain new kinds of roles that are, for India at least, completely new. So data auditors, for example, is something that significant data fiduciaries will have to do. You will going to see people trying to provide data protection impact assessment services. And then I think also there's a new, a relatively new innovation in the Indian law of consent managers, right? Something that isn't actually found in any other jurisdiction today in a mature sense. I think there's some hints of a similar kind of model in Europe under the Data Governance Act, but it's still very nascent. And actually, this is something I wanted to ask Mini from before, and Abhijit really helped us set the context for that. Mini, could you give a sense of what's the current ecosystem today for companies actually looking to comply with these different obligations? Who can I look towards for doing a data audit or a data protection impact assessment? What should I be looking for in a service provider of those services?
Sure. So Varun, like you said, right, any significant data fiduciary will qualify for all of these aspects. Now, there will be enough and more corporates who will fall under significant data fiduciary based on volume, based on sensitivity, based on high-risk processing activities, etc. Now, if you look at the ecosystem, yes, we're not very well equipped. Yes, there are organizations that exist like ours, like other audit companies, other privacy organizations, but the scale that we're talking about is huge. Right? With all of us put together, with all of us really providing services, we will need more. And we are looking forward to corporates helping out build these. So the skilling becomes extremely important. Today, we do not have an ecosystem where we have maybe, programs that kind of formally educate and certify data auditors for such purpose. So while we do have programs around security audits and others, but probably there is now case in point also for around privacy audits. There is a case in point around saying, how do you actually build capabilities and maybe certify individuals to be DPOs? And we do have such programs, say in France, that do exist. So how do we kind of say bring that ecosystem here? Because that definitely is a gap. The other thing that if you look at it, the whole framework around third party that Bibhav also talked about, how are we bringing in that diligence entire ecosystem around? How are we bringing that governance frame around these third parties as well? Because there is a corporate and then there is this long chain of suppliers and distributors and the end-to-end supply chain, right? And we know that there are no obligations on a data process, and I believe that's one of the questions as well. There are no obligations. So how do we ensure that it's not just us as a corporate, it's not just having some of these blocks who support us in being compliant, but how do we ensure this kind of runs through the chain? So the education and the skilling that we're talking about is not just for me as a corporate, but also all my partner ecosystems. And it's also somewhere maybe as corporates, we should all join hands to create that. Because while the government is trying to do that, the government is trying to create a mass awareness, the scale is huge. We're talking about a lot to be done, and the government is talking about 6 to 9 months. So yes, there is a lot that needs to be built at an ecosystem level. There is a lot of skilling that needs to be done, certification programs, auditors that probably need, and we will see a lot of freelance auditors also. This is an opportunity not just for tech players, but probably individuals who are into freelancing, gig, to say how do they skill themselves and come up on the bandwagon. So enough and more to be done. And what, like you said, from an ecosystem perspective, as a corporate, we also need to start looking at our entire visibility. What is it that we know of? Frankly, the focus has been really on saying, let's put notice, let's put consent, let's have something there. But do we even know what is the personal data we're dealing with? Do we even know what are those touch points? And yes, we may have done a GDPR, but please understand GDPR has 6 lawful bases. We have only 2. So have we done that assessment to say across our processing activities, what lawful basis am I going to apply, and how does this then fall into place? So lots to be done, internal, external, environment, and yes, there is a lot lacking in the ecosystem yet. So it's not just us as corporates, but we need to ensure that we contribute towards building the ecosystem as well.
Very interesting point, Mini. I think it's fair if we say that you will not have this ready-made ecosystem. It is a new law, so the expectation shouldn't be there. And also, at this point in time, it is on best effort basis and the intent, how an organization and the board is driving this, that therefore becomes very important, right? That is the intent there, and the best effort basis is that visible. Stephanie, you have now heard a lot of our fellow experts speak, and also Mini mentioned this, that the processor has no liability. But I want to flip that point to ask a question. And typically a controller or a fiduciary, because he has all the liability, to the extent possible, will try to secure in the back-to-back contracts a kind of comfort where the processor contractually is liable or is accountable for a lot of the stuff which he or she can be made accountable. So given your vantage point from an industry point of view, then when one is approaching this matter of contracts, I mean, what is your experience been, and what is it that you think that, what as processors, I mean, what is the kind of actual contractual obligations where you say that there are certain things one should start expecting now, which weren't on the table earlier? So you might fight it, but you will have this. And there are certain things which you shouldn't expect, even if the negotiation is a bit asymmetrical, but it's not fair for you to take it up. I think just that could be a useful conversation for us. Thanks.
Yep, sure. So as having spent most of my career working in a B2B context as a processor or service provider to other companies, this is something, a question that comes up a lot. Yes, arguably you're not directly responsible for wealth of consumer data, wealth of end user data, but you are ultimately accountable to your clients, to your customers, for how you treat and manage that data on their behalf. So certainly from the time of GDPR, and even before that, as the US started implementing data breach legislation and those sort of requirements, this has become a huge issue for processor organizations or service provider organizations. I can graph show the evolution of the types of questions we get from clients in RFPs. The growth of client expectations on their service providers, I think, has been huge through GDPR, but even prior to that. We certainly feel accountable under GDPR. At least we have direct responsibility for security measures, for aspects of data breach obligations, flow downs to further sub processors or subcontractors down the chain, which need to be managed. So there is an awful lot there. and it is a heavy burden for all organizations to ensure they're able to manage. I think the transfer of risk or liability from the fiduciary to the processor will be an interesting thing to see in an Indian context. I think experience in Europe and the rest of the world has shown that it absolutely does happen. It is a little bit dependent on jurisdiction, but clients can be very demanding. Clients can look for unlimited liability in certain cases. Clients in regulated sectors take a very different approach in some cases. So there can be a transfer of liability. There can be extremely high, unlimited, high caps. There can be responsibility for ensuring the legality of certain processing operations. So post Schrems, I don't want to go into that, but around data transfers out of Europe, for example, who is responsible for ensuring the GDPR legal requirements are met there? Is it the fiduciary in the Indian context, or would it be the service provider processor? So there's a lot of evolution as well in terms of how where those obligations sit, who's responsible for compliance, whether contractually or legally under the law. So yeah, I think it's a complex area, and in some ways, back to the first point, it's still evolving in Europe and other jurisdictions. So it'll be a moving field, I think, for a while yet.
Just a very quick follow-up on this, that do you see a role for government in this in terms of the contractual obligations, or is it something that will be entirely left to the market in the Indian context? Do you see some role for some kind of template or guidances, because there are all sorts of bargaining positions, right? As you mentioned, just a quick answer on that.
Yep. I will try and be quick. And we have experience, obviously, in Europe and other jurisdictions with standard contractual provisions, sometimes mandated, you have to use them. Sometimes they will put a model clauses out there that organizations can use, and they do influence the market positions between customers and providers. It needs to be weighed up, and I think it's a sort of bigger regulatory question for any government to look at. How do we try and ensure fairness between different players in the market, and smaller and the bigger organizations with more bargaining power? But how also can we limit the level of effort, I think, that organizations need to put in place in negotiating and, trying to all get comfortable. If we do have a standard, then everyone works to that. So yeah, I don't have the answer. I don't know if there is a right answer, but I think it's a very interesting question from a regulatory perspective.
Thanks, Varun.
Thanks, Stephanie. I think, this actually flows really well into my next question that I wanted to ask to everybody with a little bit of GDPR experience. We've been talking to a lot of companies about just interpreting the new law because we're thinking about how the implementation should work out. And a recurring question that keeps coming up, something that I'd love to ask you, Monika, but also Stephanie, Bibhav, please come in. The Indian law now has this new phrase. It's called technical and organizational measures that a data fiduciary must introduce. And there isn't a rule-making power for that particular phrase. So, Monika, actually, I'd just love for you to just kick us off on trying to understand what does the phrase actually mean, and what should companies be expecting, what all fits into the bucket, and then we could have other people join in as well.
Thanks, Varun. And it is a very good question. And I think that even after, all those years of GDPR in other jurisdictions, I don't think that there's like one answer to this question. I think there is a number of dimensions, I would say, to this topic. So first, I think it's the dimension of like coming back to our accountability discussion in terms of the technical or organizational measures that you want to put in place as a part of your data governance. And, how you look at, I think there were a number of references here to, like you have to look at data with a tech lens. You have to understand the business landscape and identify the governance model that works best for your organization. And you be very much differ between a regulated financial entity and and an entity that is experimenting with a B2B model whereby most of its data, it's not even personal data. So I think there is not like one standard for everybody. However, what we see is a little bit the evolving nature of expectations that companies are subject to. And I think that's in particular from a sort of data governance and security perspective. So we have external existing references such as, guidance from security agencies such as NISA and NIST and, the Singapore Data Protection Authority, which set certain expectations as to what is good enough. And I think that this cannot be ignored in the India context, not necessarily that they have to apply word by word or just automatically, but there is existing sort of scientific approach to what is good enough from a sort of technical and organizational measure perspective. The other dimension that I think will tie back to what Stephanie mentioned and also Bibhav is what are your expectations towards third parties with whom you entrust with your data. And here what we saw is a lot of evolution in terms of standards such as ISO and SOC 2 Type 2 reports and other types of external certifications, which to some extent provide assurance for organizations that entrust others with specific nature of the data. I think someone mentioned in the chat, like, how companies will deal with the fact that there's no differentiation between sensitive personal data and just other types of personal data. I think this will be exactly the decisions and the assessments that companies will have to do in terms of how they treat various categories of data with different levels of diligence and expectations and standardization. And a company that needs to entrust a data processor with processing its medical records of employees and vast employee files containing all sorts of information will have a higher degree of technical and organizational standards that they want to expect versus a company that may just entrust someone with like a mailing operation. So I think this is even though the differentiation is not there, it will be part of your governance assessment and your third-party risk management model. And this is the technical and organizational measures is an important part of your vendor management. Of course, it also applies to organizations themselves in terms of how they set up. And and this is the interesting part about this is not static. Like I do recall like years ago when we were trying to enforce encryption as a part of standard offering of service providers, and they were like, no, this you have to pay extra for that. 2 years onwards, and everyone was kind of offering this, in the entire data chain as a part of the standard offering. So you also have to have a monitoring and assessment mechanism in place to see how the external landscape evolves and what are the evolving expectations of regulators. And coming back to Abhijit, this all being about tech, I'm pretty sure that the board will also have a tech approach and will be following the developments to make sure that there is an understanding of what is good enough. But I would be very concerned if this goes into very prescriptive approach to technical and organizational measures, because it's best sometimes to adjust it to really the business model and the level of risk that organizations have to do. So it's not that standards are not there and it's all the Wild West, but at the same time, a very prescriptive approach, like, for example, even though, there's no rule-making power, but potentially some sort of very prescriptive guidance may not be the best solution because they outdate very quickly. And in some cases, they may create frictions for organizations that have to just look at this one model around. Yeah.
So thanks, Monika, and that's really helpful. I think one thing that is coming out as we start looking at the new law and start comparing it to just how data protection laws in other regimes work, I think it's a little unclear where this would come out. Maybe it'll come out in practice, but we're eventually going to see a risk-based kind of approach organically perhaps grow into the marketplace, and things will have to continuously evolve, which is perhaps the new element to compliance that Indian companies now have to think about, right? It's a continuous process. You can't just build, leave, and forget, in a sense, right? So Bibhav, you've had your hand up for a long time, so I'd love to come to you. And
no, initially the hand was raised by mistake, but this time I just wanted to add, I'll just keep it limited to Monika's point on the GDPR. One of the things is that if you see the GDPR also, technical and organizational measures are not defined. I think Monika touched upon it. It's ambiguous to the extent, and I think it's beneficial for the industry. One of the things you have to realize with DPDA also is that we've taken this approach that we keep the substantive or the act simple. With simplicity comes ambiguity in a digital operation, right? And therefore, that is what we have. And I think as an industry, we all are struggling, whether you go and speak to a 25-year experienced law firm partner who's worked with SPDI, who's looked at GDPR, etc. They themselves are currently struggling to define the nuances of what would be acceptable in the Indian context, right? However, from all the information that we've gathered through industry conversations, or even with MeitY and the related ministers, etc., what we've understood is that it will develop as we proceed, and it will be a learning exercise. The only hope, and therefore, as Ashish very succinctly and rightly pointed out, is that we can't wait for, it's very uncomfortable as a lawyer for me to not have everything in black and white saying that this is what has to be done to comply. It's left to a lot of interpretation, and I can understand the discomfort. But I think what we've learned, and we all would agree, is that we need to start on it and on a reasonable effort basis to understand what reasonably would constitute compliance from a privacy-centric manner and start doing it. In technical and organizational, technical is very simple. It's self-explanatory. Technical would be anything to relate with security. While you say that there's no specific carve-out for technical and organizational measures, there will be security standards, the likes of ISO 27701 is considered to be, if you have certification, and then maybe considered to be reasonable security practice, the way the IT rules had it. It may come through that format, but technical would be security. Organizational would be the corporate governance aspects that we spoke about. How are you leading it? How are you leading training, cultural shift in handling of personal data? All of those get classified. That's the limited understanding I have from a GDPR perspective. That's how they classify technical and organizational measures. I think I would want it to be not prescriptive, so that I, according to the type of data, will be able to decide as to the stringency of measure that I need to adopt as an organization. So therefore, that ambiguity does help the industry.
So I just actually really wanted to comment on this, because this ambiguity point can go both ways. You're absolutely right there. But one difference that I wanted to point out, as opposed to our law as compared to the GDPR, is where the phrase technical and organizational measures is placed. In our law, it's just phrased as a simple obligation. But in the GDPR, it's phrased under a term that actually you used in your earlier intervention, privacy by design, or actually in data protection terms, GDPR terms, data protection by design. And so this is interesting, right? Because it connects throughout pretty much everybody's comments today. It connects to Abhijit's point also on how to leverage tech, right? So it would be great if Bibhav and Abhijit also, if you could come in, just help us understand what does privacy by design or data protection by design actually mean? And perhaps Monika and Stephanie, if you could also help us, this could be the last question that we spend a little bit of time on. Anything from your global experience that can also help companies think about embedding privacy by design or data protection by design? Any resources or guides or best practices that you think it would be good to also think about? So this idea, if everybody could unpack.
What I'll do, Varun, is that I'll keep it limited. There are a lot of people who are going to add on to it, and the question that you've asked is a loaded one. It's going to cover everything under compliance that is required, whether under GDPR or DPDA. But a couple of things that I think as an organization or as any person advising on privacy compliance need to take care of is, as I said, understanding a data life cycle, how the data is collected, processed and stored subsequently and disposed. That is something that needs to be understood. And anything you do to ensure that privacy is protected or risk to personal data or privacy of that individual is minimized would be considered privacy by design. Now, to start with, first principle that you can start with is that is the data required, data minimization as a principle. Is that something that is necessary? Is it a good to have, must have? Itself as part of your assessment process would be a privacy or privacy by PBD intervention. Similarly, when you come to onboarding third parties who help you process this data, whether analyze, etc., whether you're taking the right assessments to ensure that the data is protected through that life cycle in the same manner that you do commit to a consumer, followed by cybersecurity processes, assurance processes of the data moving in from your system to third-party systems. All of those would be considered privacy by design, because something that fundamentally exists as part of your organization that will enable any data processing activity, personal data processing activity, to undergo these checks and balances to mitigate all those risks. So anything that you can think of, whether it's security standards, whether it's assessing third parties, minimizing data, pseudonymizing data that is not required necessarily, all of those I think would be practices that come under PBD, and hence the entire data lifecycle will have to be looked at. I'll let the other panelists. Oh, sorry, Ashish.
No, so maybe maybe you have answered, and but I want to add a point which maybe other can pick up. So privacy by design, right? You said. Now, who takes the final call on what is right? Because the head of marketing or sales will have a different idea of privacy design. Similarly, let's say, other functions, the tech team may have a different idea, and DPO might have a different view. So when you're looking at it as an organizational view, so who is the umpire here? Who is the referee who says this is what will go? I mean, is that something that is important for an organization to fix?
It is, and hence at least my learning is that you have a data privacy office in-house that gives you the accountability when you're refusing a business to collect data, because it's very easy for a service provider providing data privacy services to say that, or as we get all the disclaimers that we get when audit reports are submitted or legal opinions are provided by our law firms, that is not something that is available within our teams, right? I think a data privacy team, whether a lawyer or a technical person from the cybersecurity division, whoever it is, a neutral, I think, person responsible for compliance, because at least in all my conversation, the zeal to collect more data with the talk around how important data is, the zeal to collect more data from a future perspective as a good to have is always there, and that creates bias. So that I would say neutral.
Yeah. So let's quickly get some more input. So Abhijit, are you also then the man in hot seat to take these decisions, or I mean, these kind of decision persons like you in your role? I mean, any comment on the question which Varun had posed? Yeah.
Interestingly, I have a very simple response for this. It's called balance. Now, let me elaborate on this. When I was talking about tech earlier, and I'll answer your question, Ashish. When I was talking about tech earlier, right, it's about balance. And I saw in the chat a comment about, do we go completely this way on tech? Do we go? No, it's about balance. So even on the point you're talking about, it's about balance. See, no organization, right? Yes, there are decision makers. Your CEO sits right at the top of that tree. You have the chairman of the board, etc., etc. But you'll rarely see organizations have 6 people with 6 different views, and then they'll say, okay, you're the umpire, now you take a call. Organizations work with a cohesive principle. So when you're talking about privacy by design, if your marketing team has a certain view, your HR function has a certain view, your CTO org has a certain view, legal has one, DPO has one, you'll very rarely see a situation where it's like people in a conference room arguing and yelling and screaming, and then you say, all right, chief, and you point to someone and say, you make that call. No, that's not how organizations work. Organizations work on balance. Your compliance policies are built on balance. And it is always an inclusive decision where you say, okay, who's most well qualified to interpret the law? You'll go to the legal department. Who's most well equipped to maybe build those controls from a compliance standpoint, your compliance organization, and so on and so forth. So to answer your question directly, Ashish, no. I think that's an interesting question, but it's a hypothetical question.
Okay, all right. No, I completely hear you, but I'm just going to put it to Stephanie and Monika to say that a company which is doing this for the first time, Abhijit has a very optimistic and a nice view that it is all going to be smooth and in an organization and the cohesive approach will play out. But you have experienced it in other jurisdictions. So in your experience, is it really that smooth to have a one view of privacy by design, and what is the takeaway for our audience on that? So with that lens, if you can quickly share your view, and that would be the wrap on this part of the conversation.
I'll be very quick because I'm sure Monika has something very insightful to add as well. I think, my role, or the role of a privacy function, is several-fold, including the specific mandated DPO role that exists under GDPR as well, around monitoring and compliance and advising the business. It is primarily an advisory role. So when I look at privacy by design, it is about understanding data lifecycle. It's understanding where those natural controls and checkpoints need to be, and it is building over time those controls to cover privacy requirements and ensuring the governance around those controls being followed by the business. And obviously that matures over time, but first step in any program is really understanding data, understanding the risk. Interesting point that, we're not looking at sensitive data under the India law, but I think it's taken for granted that you would have to. So, and in terms of the function and decision making, I think, again, the privacy function is advisory. So we're telling the business or advising the business on how they can comply with the law, how they can implement a particular initiative. And that comes back to the value of this role. It shouldn't just be a cost center. It shouldn't be pure compliance. It's really about enabling the business, but it's a business decision on what they choose to do. And that, again, the independence of the DPO role, there needs to be, if advice is contrary, it needs to be documented, and that is retained as part of your overall governance and accountability processes. But yeah, I think the balance needs to be there. I'm sure it's not smooth all the time, but the balance absolutely needs to be there. I'll let Monika jump in.
Yeah, I think the point about documenting and advisory role, I think that can work in terms of cohesion as well as making sure that you have done your role well. Monika, what's your take on privacy by design in an organization?
Yeah, I kind of very much agree with what has been said before, that it's not like one solution. It's a whole spectrum of data governance tasks. And I think it's one of the most challenging parts of privacy laws, to be able to demonstrate how your organization in its totality adheres to the privacy by design principle, because those elements and responses, really, it's not like you can just say, okay, like my product and tech team, they all train, they have the control, they have the technology. When they deploy new products and services, they have very much privacy by design in front of center. Yes, they do. But then what about maybe your marketing people that have been mentioned here, or your HR function that wants to introduce an employee monitoring tool? So it's really like across, and it's probably like never achievable in its kind of like, I would say, golden standard. You always strive towards this being implemented across the organization. Doesn't mean that you should not be trying. I think that the journey is there. And coming to the point about like who decides, I do agree with Abhijit that this is, the art of dialogue. And ultimately, there is usually a whole range of risk assessment and mitigating controls. That's why, even though, the data protection impact assessment is reserved in its formal sense just for the significant data fiduciaries, I think this is an exercise that I very much recommend every company to go through, because this is where you'll get that balance right. And usually there's a whole spectrum of things that may happen in terms of like, where the business want to go, what the mitigating controls that need to be applied, and ultimately the final result, which is acceptable by all the stakeholders. And, is it frictionless? No, it isn't. Sometimes there are frictions, in particular when companies are faced with stringent and complex legal requirements like we have faced in the sphere of international transfers. So we were very happy to see that currently, under the DPA, there aren't any immediate obstacles for international data transfers, because this was a challenging area in terms of the frictionless application of privacy for organizations when they were faced with this outright prohibitions to some extent, and they had to assess the risks. So I think risk assessment and coming to a conclusion of an acceptable risk for the organization is an art in itself. And this, this risk appetite may be different. If you're a regulated company which is listed, you have to operate within your risk assessment framework, and you may have a slightly different approach when you're at earlier stages of maturity of your organization. But that assessment needs to take place in order to go into it with the open eyes and the understanding of those risks. So I agree that usually there's a lot of dialogue that has to happen. In particular, I think that has been mentioned, Mini mentioned that, and my fellow panelists, that there will be a lot of uncertainties in relation to those pieces of the DPDPA where, if you read the requirement, you might like, oh, okay, so how are we going to actually operationalize this? So there will be some degree of certainty coming of the rules, but I'm pretty sure that there'll be still many, many questions where we all have to figure out the best answer for our organizations in terms of the ability to do this risk assessment.
All right. I think the one message which I also take from your comment is that we could be chasing the perfect privacy by design, but it is important to get on that journey and the right intent, and it will evolve. So with that, I think we are completely out of time. It has been a fantastic discussion. We got some new insights, and we had a very diverse set of experts. So thank you, Mini, Monika, Stephanie, Abhijit, Bibhav, and of course, Varun. And we will be taking some of this conversation forward from a nasscom point of view. I think it's great for industry to be thinking and working on protecting themselves from a governance perspective, but also from implementation of privacy by design itself. This law has stringent penalties, so it is not just a matter of a simple compliance. I think they range from 50 crores to 250 crores. So one should definitely look at it from a serious compliance issue also. And to all our participants who have been onto this call, you have follow-up questions which you have not been able to take, please write into me and Varun. We will continue to build on this, because one of the objectives is to try and build a conversation and community around the implementation journey, whether it is 9 months or 12 months or more. I think the more we talk to each other and I think bounce off some of these things, it is generally useful. So with that, thank you. Thank you, everyone. Bye-bye.
Thank you. Bye.
Thank you, everyone. Bye-bye.